Hi friends, good morning. Welcome to UPSC World. This is Dr. Harinath Reddy, Director of the Institute. Today in this particular video, let us try to discuss one important topic which has been in the news, that is accountability in the higher judiciary. What do you mean by higher judiciary? See, higher judiciary includes the Supreme Court and the state high courts. So in the recent past, one judge from the Delhi High Court, Yashwant Verma, he has been in the news. So Yashwant Verma, in the house of Yashwant Verma, the burnt cash was discovered and it was alleged that he had unaccounted money in the house. And that led to a formal inquiry against the judge by the Supreme Court Chief Justice of India. So this has been in the news. In this context, let us discuss the accountability of the higher judiciary in India. If you remember, in the last 75 years, there are several judges who have been under the scrutiny and on whom allegations have come up questioning the conduct of the judges. So starting with K. Veeraswamy of the Madras High Court. Madras High Court Chief Justice K. Veeraswamy, then Justice Ramaswamy of the Punjab and Haryana High Court Chief Justice of Punjab and Haryana High Court Justice Ramaswamy, then Justice A.M. Bhattacharjee, Chief Justice of the Bombay High Court in 1990s, then we had Justice C.V. Nagarjun Reddy from Andhra Pradesh, then you have Justice Soumitra Sen from Calcutta High Court, Justice P.D. Dinakaran from Karnataka High Court, Justice Ganguly from the Supreme Court who faced allegations of sexual harassment, and Justice Shekhar Yadav of Allahabad High Court who faced allegations of hate speech against Muslim minorities. In addition to this, Nirmal Yadav, one of the judges who was alleged to have accepted 10 lakhs of money at her doorstep, is one more judge which has been under the scrutiny. The most recent one is Justice Yashwant Verma. So these are several judges whose conduct was questioned in the past. So this is the context in which we need to see the accountability of the judiciary in India. And why the accountability in judiciary is very important. We should all recognize that in any democracy, if the executive fails, if the legislature fails, there is a judiciary to correct the executive and legislature and thereby protect and promote democracy in India. If judiciary fails, then democracy in India fails. That's the reason why we need people of very high integrity and ability to become the judges of the Supreme Court and High Court. So in the initial decades of independence, we had a balanced role for the executive and the judiciary in making appointments to higher judiciary. But in the second judge's case in 1993, the Supreme Court has come up with an institution called collegium. So in the collegium system, judges are appointed by judges. Collegium has been in place for the last 3 decades, and this system has not inspired confidence. There were several allegations that the system of collegium doesn't work transparently. It works behind the iron curtain. There is a lot of opacity. Then when the judges are appointed to the High Court and Supreme Court, the considerations of caste, the considerations of class, the considerations of money is playing an important role. It means the existing system of collegium, which has come into place in 1993, has failed in appointing the people with highest ability and integrity to become the judges of the Supreme Court and High Court. And now we are facing the problem when wrong people get into Supreme Court and High Court, it has become very difficult to remove them because the existing procedure which is laid down in the Indian Constitution for punishing the corrupt judges is under Article 124 Clause 4 and Article 217. And along with Article 124 Clause 4 and 217, there was a law made by the Indian Parliament in 1968, Judges Inquiry Act 1968. So the Constitution says that a judge can be removed on the grounds of proved misbehavior and incapacity. And the procedure was laid down both in the Constitution and also in the Judges Inquiry Act. In the Constituent Assembly debates, there were suggestions from some of the members of the Constituent Assembly to set up for a judicial tribunal. But Alladi Krishnaswamy Iyer, he wanted a mixed process, a political process combined with a judicial process. And that is the process which we have in place today. So, according to the Judges Inquiry Act 1968, 100 members of the Lok Sabha or 50 members from Rajya Sabha shall pass a motion and submit it to the Speaker or the Chairman respectively. And if the Speaker admits and if the Chairman admits the motion, then a 3-member committee will be appointed to investigate the charges of corruption. And this 3-member committee will contain a distinguished jurist, a judge of the Supreme Court, a Chief Justice of the High Court. So this 3-member committee will inquire into the allegations against a judge of Supreme Court or High Court. This is the judicial process. Then on the basis of the report, if it is found that the judge is guilty of proved misbehavior and incapacity, then the removal of the judge is taken up in the Lok Sabha and Rajya Sabha through a removal motion. So in the Lok Sabha and in the Rajya Sabha, the motion for the removal of the judge of High Court and Supreme Court shall be passed by special majority. A majority of the total membership and 2/3 of the members present and voting. Once the removal motion is passed by Parliament, Lok Sabha and Rajya Sabha by this majority, then the President can formally remove the judges of the Supreme Court and High Court. But in the last 75 years, it was proved beyond reasonable doubt that this mechanism has proved in disciplining the corrupt judges. Because in the last 75 years, we tried around 8 times to remove the corrupt judges. But this has miserably failed. So the existing impeachment procedure for removing the corrupt judges of the Supreme Court and High Court has proved to be impractical for removing the judges of the Supreme Court and High Court. Then what is the other alternative which was provided? Let's look into that. So here I said why it has been in the news. Then what is the importance of judicial accountability? The next one is, so there is something called in-house procedure to discipline the judges. So this all began in the 1990s. In the 1990s, in one of the important cases, Ravichandran Iyer versus Justice A.M. Bhattacharjee 1995. This is the judgment which was responsible for the present in-house procedure for investigating the deviant judges. Later on, in Indira Jaising versus the Registrar General of the Supreme Court, the purpose and the structure of this in-house procedure was clearly laid down. So, 2 important judgments: Ravichandran Iyer versus Justice A.M. Bhattacharjee 1995, Indira Jaising versus the Registrar General Supreme Court 2003. These are the 2 judgments which paved the way for the in-house procedure within the judiciary. But here you should remember the 3-member committee which was appointed by the Speaker or the Chairman under the Judges Inquiry Act 1968 is totally different from the in-house inquiry committee appointed by the Supreme Court Chief Justice of India. So when it comes to the in-house procedure, it was laid down not by a law, not by the provisions of the Constitution. This was laid on the basis of the judgment of the Supreme Court through guidelines. And the in-house procedure laid down by the Supreme Court in its judgments, it says that when there is a complaint of corruption against a judge of High Court, then the complaint can be made to the Chief Justice of the High Court. If the Chief Justice of the High Court is not inclined to look into that complaint, then the complaint can be made to the Chief Justice of India. So the Chief Justice of India can advise the Chief Justice of the concerned High Court to look into the issue whether there is prima facie evidence to proceed further with a detailed inquiry. Then if the Chief Justice of the High Court confirms that the allegations need a detailed inquiry, then a panel of 3 judges will be appointed. So this panel of 3 judges will include 2 Chief Justices of the High Courts from the courts other than the court to which the corrupt judge belongs to, and 1 judge of the High Court. This is the composition of the panel. So the panel will go into the details of the inquiry, will inquire the concerned judge. The judge will have an opportunity of being heard. He can present his case before the panel. Once the panel submits the report that he is found guilty, then on the basis of the report of the panel, the Chief Justice of India can take certain corrective measures. What are they? The Chief Justice of India can ask the concerned judge to resign or to go for voluntary retirement. If the judge is not complying with this, then he will be not allowed judicial work. So the Chief Justice of India can suggest withholding judicial work from the corrupt judge. So these are the powers which are available to the Chief Justice of India to discipline the deviant judge. When the allegations of corruption are against a judge of the Supreme Court, then a 3-member panel consisting of the senior judges of the Supreme Court will be constituted. This again will do the same inquiry, and on the basis of the inquiry, then the judge will be either asked to retire or to resign, or the judicial work will be withheld from the concerned judge. Then there is a problem with even the in-house procedure. The problem is the in-house inquiry conducted by the Supreme Court through the Chief Justice of India is not transparent, which means what are the findings of the report, what is the progress of the inquiry, nothing will come into the public domain. So there is lack of transparency and there is opacity even with respect to in-house inquiry conducted by the Supreme Court. So these are the problems with the in-house inquiry. Then what is the way forward? If you take a country like United Kingdom, in 2005 there was an important legislation made by UK Parliament, Constitutional Reforms Act of 2005. Under this Constitutional Reforms Act of 2005, the Supreme Court Chief Justice of United Kingdom can go to the extent of suspending a corrupt judge if the allegations are proved to be right. So we can look into the Constitutional Reforms Act of 2005 in United Kingdom with respect to what needs to be done in India. Then the next one is Courts Improvement Act 2002 is one more legislation made in United States of America by the US American Congress. So this is one more guidance for India to make a legislation to deal with the deviant judges. So in 2010, a bill was introduced in the Parliament, Judicial Standards and Accountability Bill 2010. So this was one attempt, but unfortunately this bill couldn't become a law. In 1997, in the context of the allegations against Justice A.M. Bhattacharjee, in the Chief Justice's Conference in 1990s, a decision was made to lay down the values of judiciary in public life. That finally led to a restatement of judicial values in 1997. The restatement of judicial values in 1997 will lay down the code of conduct for the judges of the Supreme Court and High Court. So the Judicial Standards and Accountability Bill 2010 wanted to give a legal backing to the restatement of judicial values. But remember, even with respect to in-house inquiry conducted by the Chief Justice of India, there is a problem. The Chief Justices of India will have a very short tenure. So when there is a change of Chief Justice of India, the focus on the inquiry done in-house will get affected. So the Judicial Standards and Accountability will propose a new body called a National Judicial Oversight Committee. So this will contain a retired Chief Justice of India, a judge of the Supreme Court, a Chief Justice of the High Court, an Attorney General and a nominee of the President. So this is a permanent body to look into the complaints of corruption against the judges of the Supreme Court and High Court. So we will get into more details of the Judicial Standards and Accountability Bill in the next video. So till then, this is about the accountability of the judiciary, higher judiciary in India. This is what is going on in India. As I said rightly, in any democracy, it is absolutely necessary to have people with the highest integrity and ability in the judiciary. Because if executive and legislature fails, the judiciary will correct the executive and legislature. If judiciary cannot correct itself, then that will undermine the faith in democracy, the faith in judiciary, that will pose a threat to the democracy in India, and that's a very danger for the future of India. So keeping in mind all these proposals, that we have certain examples from United Kingdom, certain examples from United States of America, we can learn from the best practices across the globe in disciplining the erring judges. And accordingly, there is an imperative need to make a law through the Indian Parliament to deal with the deviant judges, providing all the details with respect to the framework and the structure and process of dealing with the deviant judges. Thank you and all the best.